Question 376. In order to authorize a conventional loan, many lenders require an applicant to have a financing assistance from a friend or a relative for a down payment, b. 2 months or more of mortgage payments in reserve, c. a steady job with the possibility of advancement, d. 3 or more previously paid in full mortgage loans. Correct answer is b. 2 months or more of mortgage payments in reserve. Lenders often require borrowers to have a certain amount of funds in reserve, savings, checking, etc., in addition to the down payment and closing costs. These reserves act as a financial cushion to help the borrower continue making mortgage payments if they experience a temporary financial setback, such as job loss or unexpected expenses. 2 months of total housing expenses, including principal, interest, taxes, and insurance pity, is a common guideline. Borrowers with a higher amount of reserves are viewed as lower risks. Question 377. Blind ads are a. set up so consumers who respond believe they will be speaking to the seller, only to be connected instead to the agent posting the ad. B. designed to be accessible to sightless individuals, c. illegal, d. both A and C. Correct answer is D. both A and C. Blind ads, in the realm of real estate, are a form of advertising designed to mislead the public into believing they are contacting a property seller directly, when in reality, the communication is being initiated and managed by a real estate agent. These advertisements typically omit the name of the real estate agent or brokerage, creating a false impression of direct seller contact. The intent behind such ads is often to generate leads for the agent, who can then attempt to represent the prospective buyer or secure a listing from the seller they indirectly contact. However, the practice of using blind ads is widely considered unethical and is, in fact, illegal in many jurisdictions, including California. Real estate advertising regulations are in place to ensure transparency and prevent deceptive practices. These regulations generally mandate that all real estate advertisements placed by licensed agents must clearly and prominently display the name of the agent and their employing brokerage. This requirement allows consumers to readily identify that they are engaging with a real estate professional and not a private seller, fostering a more honest and transparent marketplace. The prohibition of blind ads serves to protect the public from potentially misleading marketing tactics and upholds the principles of honesty and integrity within the real estate industry. These regulations aim to ensure that consumers are aware of whom they are communicating with from the outset, allowing them to make informed decisions about their real estate endeavors. Question 378. The authority to investigate non-licensees believed to be performing real estate activities for which a license is required is held by the A. Police, B. District Attorney, C. Real Estate Commissioner, D. State Legislature. Correct answer is C. Real Estate Commissioner. The primary responsibility for enforcing real estate license laws and protecting the public from unlicensed activity falls under the purview of the state's real estate regulatory body, headed by the Real Estate Commissioner, or a similar title. This agency has the specific authority and expertise to investigate individuals or entities suspected of engaging in real estate activities without the necessary licenses. The Real Estate Commissioner's Office is primarily responsible for investigating non-licensees suspected of performing real estate activities requiring a license. Although law enforcement agencies may become involved if additional illegal activities like fraud are suspected, the initial inquiry into unlicensed real estate practice falls under the Commissioner's authority. The state legislature establishes the laws and the Real Estate Commissioner's Office is tasked with enforcing those laws. Question 379. Ronald presented an offer to Joan to purchase her house, with the provision that Joan respond within a week of getting the offer. Joan was considering 2 other offers to buy her house, but ultimately decided to accept Ronald's offer. 9 days after she received it, Joan asked her broker to communicate her acceptance of Ronald's offer to him. In this situation, A. Ronald is obligated to go ahead with the purchase. B. Ronald is under no obligation to go ahead with the purchase because Joan did not personally tender her acceptance to Ronald. C. Ronald is obligated to present a counter-offer that provides another opportunity for Joan to accept it in a timely manner. D. Ronald is under no obligation because Joan's manner of acceptance did not match a term of the offer. Correct answer is D. Ronald is under no obligation because Joan's manner of acceptance did not match a term of the offer. Ronald's offer clearly stated that Joan needed to respond within 1 week of receiving the offer. This established a specific time limit for acceptance. Joan attempted to accept Ronald's offer 9 days after she received it, which is beyond the 1-week deadline stipulated in the offer. The offerer, Ronald in this case, has the right to specify the terms of acceptance, including the time frame. An acceptance that does not adhere to these terms is generally considered a rejection and a counteroffer. While Joan didn't personally tender the acceptance, communication through her broker would generally be considered valid, if the acceptance had been timely. The primary issue here is the lateness of the acceptance, not the method of communication. Ronald is not obligated because Joan's acceptance was outside the timeframe specified in his offer. Question 380. Types of real estate financing include the following. A. Assumptive. B. Equity. C. Debt. D. Both B and C. Correct answer is D. Both B and C. Debt financing is the most common type of real estate financing and involves borrowing money, creating debt, that must be repaid with interest over time. Examples include traditional mortgages, FHA loans, VA loans, and construction loans. Equity financing involves raising capital by selling an ownership stake in the property or project to investors. The investors then share in the potential profits or appreciation of the real estate. Examples include partnerships, joint ventures, and real estate investment trusts, REITs. An assumable mortgage is a feature of certain types of debt financing, primarily government-backed loans like FHA, VA, and USDA. It allows a buyer to take over the seller's existing mortgage, including its terms and interest rate. It's not a fundamental category of financing like debt or equity. Therefore, the main categories of real estate financing are based on whether the capital is obtained through borrowing, debt, or by giving up ownership, equity. Question 381. When a real estate agent acts exclusively as a buyer's agent, he can do all of the following except: A. Present offers directly to the seller. B. Present offers to the seller and seller's agent. C. Withhold confidential information about the buyer from the seller. D. Act as an exclusive agent of the seller. Correct answer is D. Act as an exclusive agent of the seller. When a real estate agent establishes an exclusive buyer's agency relationship, their allegiance and legal responsibilities are unequivocally directed towards representing the buyer's best interests throughout the entire real estate transaction. This fiduciary duty mandates that the buyer's agent act with utmost loyalty, confidentiality, and diligence on behalf of their client. Their primary goal is to assist the buyer in finding a suitable property at the most favorable terms and price possible. To effectively advocate for their buyer, the agent will engage in activities such as researching available properties, arranging property viewings, providing objective advice and guidance, and strategically negotiating offers. In fulfilling these responsibilities, an exclusive buyer's agent is fully authorized to communicate directly with the seller or the seller's agent to present their client's offer to purchase. This direct communication is a fundamental aspect of the negotiation process, allowing the buyer's agent to advocate for their client's terms and conditions. Furthermore, the duty of confidentiality inherent in the buyer's agency relationship requires the agent to safeguard any sensitive information about their buyer from the seller. Disclosing confidential details, such as the buyer's absolute maximum price or urgent need to purchase, could potentially weaken the buyer's negotiating position and would be a breach of the agent's fiduciary duty. However, the core principle of exclusive buyer agency inherently prohibits the agent from simultaneously acting as an exclusive agent for the seller in the same transaction. Representing both the buyer and the seller as an exclusive agent would create an irreconcilable conflict of interest, as the interests of the two parties are typically adverse. The seller aims to achieve the highest possible sale price and favorable terms, while the buyer seeks the lowest possible price and advantageous conditions. An agent cannot ethically and effectively represent these opposing interests exclusively at the same time. Therefore, an agent acting solely as a buyer's representative cannot also serve as the exclusive agent of the seller in that specific transaction. Question 382. Which of the following actions by a broker would violate the rules regarding trust funds? A. Cashing a deposit check after acceptance of an offer at the seller's direction. B. Keeping a deposit check uncashed after acceptance of an offer at the seller's direction. C. Keeping a deposit check uncashed by their own decision. D. Keeping a deposit check uncashed before acceptance of an offer at the direction of the buyer. Correct answer is C. Keeping a deposit check uncashed by their own decision. Real estate brokers in California are held to strict standards regarding the handling of trust funds, which include earnest money deposits provided by buyers. These funds belong to the buyer until the offer is accepted, at which point they are typically held in trust for the benefit of both parties according to the terms of the purchase agreement. Brokers have a fiduciary responsibility to manage these funds with utmost care and in compliance with real estate law to protect the interests of all parties involved in the transaction. Violations of trust fund rules can occur when a broker fails to handle deposit checks appropriately. Cashing a check after offer acceptance at the seller's direction or holding an uncashed check before acceptance with the buyer's written instruction are usually acceptable. However, a broker deciding to keep a deposit check uncashed without a valid reason or instruction is considered a problematic practice. This lack of action can raise questions about the broker's handling of client funds. This unilateral action can be viewed as a failure to properly manage trust funds and could potentially lead to commingling issues or delays in the transaction process, thus violating the broker's fiduciary duties and the regulations governing trust fund handling. Question 383. Among the following factors, the most significant one affecting home value is A. Quality of workmanship. B. Buyer demand. C. Square footage. D. Ratings for nearby schools. Correct answer is B. Buyer demand. While several factors influence home value, buyer demand is often considered the most significant and dynamic. High buyer demand in an area creates competition, driving prices up, even if the homes themselves have varying qualities. Conversely, low demand can lead to price reductions regardless of a home's features or condition. While factors like the quality of workmanship, square footage, and ratings for nearby schools are undoubtedly important and contribute to a home's desirability, they are all evaluated within the context of the prevailing market demand. A well-built, spacious home in a good school district will command a higher price when many buyers are actively seeking properties in that area. However, even these desirable features won't necessarily maintain high value if overall buyer interest in the location or type of property wanes. Question 384. The recording of a lease will generally be performed by the A. Lessor. B. Lessee. C. County assessor. D. Life estate holder. Correct answer is B. Lessee. Recording a lease provides constructive notice to third parties, like potential buyers or other lien holders, of the tenant's rights to occupy the property under the lease agreement. This protects the lessee's interest in the property. Since the recording primarily benefits the lessee by securing their tenancy against subsequent claims or sales, they are the party most likely to initiate and pay for the recording. While the lessor is a party to the lease, they don't typically benefit directly from recording the lease. In fact, a recorded lease might encumber their ability to sell the property freely. The county assessor's office is responsible for determining property values for taxation purposes. They record documents related to ownership and transfers of property but are not typically involved in recording leases. A life estate holder has the right to possess and use the property for the duration of their lifetime. They are not typically involved in the recording of leases unless they are acting as the lessor for a lease that extends beyond their life estate, which would have specific legal implications. In practice, while the lessee usually initiates and pays for recording, the lease document itself requires the signatures of both the lessor and the lessee. The actual act of physically taking the document to the county recorder's office and paying the fee is what the question refers to as performed by, and this is most often done by the lessee or their representative. Question 385. To record a lease, there must be an acknowledgement of the document by the witnessed by an appropriate official. A. Lessee. B. Lessor. C. Notary. D. Realtor. Correct answer is B. Lessor. An acknowledgement is a formal declaration before a notary public or other authorized official by the person who executed the document, in this case, the lessor, that they freely and voluntarily signed it. This provides evidence of the genuineness of the signature and helps prevent fraud. The lease grants an interest in the real property, the right of possession, from the lessor, owner, to the lessee, tenant. For the lease to be recorded and provide constructive notice to subsequent purchasers or encumbrancers, the owner, lessor, must acknowledge that they are conveying this interest. The lessee signs the lease. Their acknowledgement is not typically required for the lease to be recorded. The recording primarily protects the lessee's interest granted by the lessor. A notary is the official who witnesses the acknowledgement, but they are not the party acknowledging the document. Realtors are agents involved in the transaction but are not parties to the lease agreement and therefore do not acknowledge it for recording purposes. Therefore, the lessor's acknowledgement, verified by a notary public, is necessary for a lease to be recorded and provide constructive notice under California law.